Uh, yeah, there's two ways you can become a judge. You can either be appointed or elected. It's a long story, but I was both. I was elected, so maybe you voted for me. I don't know. Every 6 years, right? Yes. Oh, I wear a new one every day. No, I don't. No. I dry clean them every day, right? Oh, there he is. No, I have one, and I dry clean them every time I go on vacation. Any other personal questions? No. Right?
You never get to meet Judge.
Well, there you go. All right, we all set? Okay. All right, are you ready? Okay. Let's go back on the record. The record will reflect the presence of all jurors, and all counsel and the defendant are present. As I said before, I know this can get very tedious and very overwhelming. That's why I wanted to kind of take a little break right here. But now I'm going to define the elements for each charge that's charged in this case. I don't want to suggest that the other instructions I just read to you have no importance. These are the ones that define the elements for you. So the defendant is charged in count 1 with kidnapping for the purposes of robbery, rape, oral copulation, or sexual penetration in violation of Penal Code Section 209B. Now, to prove the defendant is guilty of this crime, the people have to prove 7 elements. All right, there's 7 elements that go into this charge. Number 1, the defendant intended to commit rape or oral copulation. 2, acting with that intent, the defendant took, held, or detained Jane Doe number 1 by using force or by instilling a reasonable fear. 3, using that force or fear, the defendant moved Jane Doe number 1 or made Jane Doe number 1 move a substantial distance. 4, Jane Doe number 1 was moved or made to move a distance beyond that merely incidental to the commission of a robbery or rape or oral copulation or sexual penetration. 5, when that movement began, the defendant already intended to commit rape or oral copulation or sexual penetration. 6, Jane Doe number 1 did not consent to the movement. And 7, the defendant did not actually and reasonably believe that Jane Doe number 1 consented to that movement. As used here, substantial distance means more than a slight or trivial distance. The movement must have increased the risk of physical or physiological harm to the person beyond that necessarily present in the robbery or rape or oral copulation or sexual penetration. In deciding whether the movement was sufficient, consider all the circumstances relating to the movement. In order to consent, a person must act freely and voluntarily and know the nature of the act. To be guilty of kidnapping for the purpose of robbery or rape or oral copulation or sexual penetration, the defendant does not actually have to commit rape or oral copulation. To decide whether the defendant intended to commit rape or oral copulation, please refer to the separate instructions that I will give you on that crime. The defendant is not guilty of kidnapping if he reasonably and actually believed the other person consented to the movement. The people have the burden of proving beyond a reasonable doubt that the defendant did not reasonably and actually believe that the other person consented to the movement. If the people have not met this burden, you must find the defendant not guilty of this crime. The defendant is not guilty of kidnapping if the other person consented to go with the defendant. The other person consented if she, 1, freely and voluntarily agreed to go with or to be moved by the defendant, 2, was aware of the movement, and 3, had sufficient mental capacity to choose to go with the defendant. The people have the burden of proving beyond a reasonable doubt that the other person did not consent to go with the defendant. If the people have not met this burden, you must find the defendant not guilty of this crime. Consent may be withdrawn. If at first a person agreed to go with the defendant, that consent ended if the person changed her mind and no longer freely and voluntarily agreed to go with or be moved by the defendant. The defendant is guilty of kidnapping if after the other person withdrew consent, the defendant committed the crime as I have defined it. Now, a lesser included offense of count 1 is just kidnapping, plain kidnapping in violation of Penal Code Section 207A. If you find the defendant not guilty of count 1, kidnapping for rape or oral copulation, you may then consider whether the people have proved the defendant guilty of the lesser included offense of kidnapping. To prove the defendant is guilty of this crime, the people have to prove 4 elements. The defendant took, held, or detained another person by using force or instilling reasonable fear. 2, using that force or fear, the defendant moved the other person or made the other person move a substantial distance. 3, the other person did not consent to the movement. And 4, the defendant did not actually and reasonably believe the other person consented to the movement. In order to consent, a person must act freely and voluntarily and know the nature of the act. Substantial distance means more than a slight or trivial distance. In deciding whether the distance was substantial, you must consider all the circumstances relating to the movement. Thus, in addition to considering the actual distance moved, you may also consider other factors such as whether the distance the other person was moved was beyond that merely incidental to the commission of the robbery or rape or sexual penetration or oral copulation, whether the movement increased the risk of physical or physiological harm, increased the danger of a foreseeable escape attempt, or gave the attacker a greater opportunity to commit additional crimes or decrease the likelihood of detection. The defendant is not guilty of kidnapping if he reasonably and actually believed that the other person consented to the movement. The people have the burden of proving beyond a reasonable doubt that the defendant did not reasonably and actually believe that the other person consented to that movement. If the people have not met this burden, you must find the defendant not guilty of the crime. The defendant is not guilty of kidnapping if the other person consented to go with the defendant. The other person consented if she freely, number 1, freely and voluntarily agreed to go with or be moved by the defendant. 2, was aware of the movement. And 3, had sufficient maturity and understanding to choose to go with the defendant. The people have the burden of proving beyond a reasonable doubt that the other person did not consent to go with the defendant. If the people have not met this burden, you must find the defendant not guilty of this crime. Consent may be withdrawn. If at first a person agreed to go with the defendant, that consent ended if the person changed her mind and no longer freely and voluntarily agreed to go with or be moved by the defendant. The defendant is guilty of kidnapping if after the other person withdrew consent, the defendant committed the crime as I have defined it. All right, now I'm going to define rape by force or fear. The defendant is charged in counts 2, 4, and 7 with rape by force or fear in violation of Penal Code Section 261A. To prove the defendant is guilty of this crime, the people have to prove 4 elements for this crime. Number 1, the defendant had sexual intercourse with a woman. 2, he and the woman were not married to each other at the time of the intercourse. 3, the woman did not consent to the intercourse. And 4, the defendant accomplished the intercourse by force, violence, duress, menace, or fear of immediate and unlawful bodily injury to the woman or to someone else. Sexual intercourse means any penetration, no matter how slight, of the vagina or genitalia by the penis. Ejaculation is not required. To consent, a woman must act freely and voluntarily and know the nature of the act. It is not required that she physically resist or fight back in order to communicate her lack of consent. Intercourse is accomplished by force if a person uses enough physical force to overcome the woman's will. Duress means a direct or implied threat of force, violence, danger, or retribution that would cause a reasonable person to do or submit to something that she would not do or submit to otherwise. When deciding whether the act was accomplished by duress, consider all the circumstances, including the woman's age and her relationship to the defendant. Menace means a threat, statement, or act showing an intent to injure somebody. Intercourse is accomplished by fear if the woman is actually and reasonably afraid. The defendant is not guilty of rape if he actually and reasonably believed that the woman consented to the intercourse and actually and reasonably believed that she consented throughout the act of intercourse. The people have the burden of proving beyond a reasonable doubt that the defendant did not actually and reasonably believe that the woman consented. If the people have not met this burden, you must find the defendant not guilty. Now I will define the allegation or the charge for count 3. The defendant is charged in count 3 with oral copulation by force or fear in violation of Penal Code Section 288A. To prove that the defendant is guilty of this crime, the people have to prove 3 elements. Number 1, the defendant committed an act of oral copulation with someone else. 2, the other person did not consent to the act. And 3, the defendant accomplished the act by force, violence, duress, menace, or fear of immediate and unlawful bodily injury to someone. Oral copulation is any contact, no matter how slight, between the mouth of one person and the sex organ or anus of another person. Penetration is not required. In order to consent, a person must act freely and voluntarily and know the nature of the act. An act is accomplished by force if a person uses enough physical force to overcome the person's will. Duress means a direct or implied threat of force, violence, danger, hardship, or retribution that causes a reasonable person to do or submit to something that he or she would not otherwise do or submit to. When deciding whether the act was accomplished by duress, consider all the circumstances, including the age of the other person and her relationship to the defendant. Menace means a threat, statement, or act showing an intent to injure someone else. An act is accomplished by force. Strike that. An act is accomplished by fear if the other person is actually and reasonably afraid. The defendant is not guilty of forcible oral copulation if he actually and reasonably believed that the other person consented to the act. The people have the burden of proving beyond a reasonable doubt that the defendant did not actually and reasonably believe that the person consented. If the people have not met this burden, you must find the defendant not guilty. All right, I will now define the elements for count 5. The defendant is charged in count 5 with sodomy by force, fear, or threats in violation of Penal Code Section 286. To prove the defendant is guilty of this crime, the people have to prove 3 elements. Number 1, the defendant committed an act of sodomy with another person. 2, the other person did not consent to the act. And 3, the defendant accomplished the act by force, violence, duress, menace, or fear of immediate and unlawful bodily injury to another person. Sodomy is any penetration, no matter how slight, of the anus by one person by the penis of another person. In order to consent, a person must act freely and voluntarily and know the nature of the act. An act is accomplished by force if a person uses enough physical force to overcome the other person's will. Duress means a direct or implied threat of force, violence, danger, hardship, or retribution that causes a reasonable person to do or submit to something that she would not otherwise do or submit to. When deciding whether the act was accomplished by duress, consider all the circumstances, including the age of the other person and her relationship to the defendant. Menace means a threat, statement, or act showing an intent to injure someone. An act is accomplished by fear if the other person is actually and reasonably afraid. The defendant is not guilty of forcible sodomy if he actually and reasonably believed that the other person consented to the act. The people have the burden to prove beyond a reasonable doubt that the defendant did not actually and reasonably believe that the other person consented. If the people have not met this burden, you must find the defendant not guilty. Now I'll talk to you about count 6, which is indecent exposure, and lay out the elements for that. In this case, there's 2 elements. The defendant is charged in count 6 with indecent exposure in violation of Penal Code Section 314. To prove the defendant is guilty of this crime, the people have to prove 2 elements. Number 1, the defendant willfully exposed his genitals in the presence of another person or persons who might be offended or annoyed by the defendant's actions. And 2, when the defendant exposed himself, He acted lewdly by intending to direct public attention to his genitals for the purpose of sexually arousing or gratifying himself or another person, or sexually offending another person. Someone commits an act willfully when he does it willingly or on purpose. It is not required that he intend to break the law, hurt someone else, or gain any advantage. It is not required that the other person or another person actually see the exposed genitals. Right now, I will define count 8, which is rape of an unconscious person. The defendant is charged in count 8 with raping a woman who was unconscious of the nature of the act in violation of Penal Code Section 261, subdivision A4. To prove the defendant is guilty of this crime, the people have to prove 4 elements. Number 1, the defendant had sexual intercourse with a woman. 2, he and a woman were not married to each other at the time of the intercourse. 3, the woman was unable to resist because she was unconscious of the nature of the act. And 4, the defendant knew that the woman was unable to resist because she was unconscious of the nature of the act. Sexual intercourse means any penetration, no matter how slight, of the vagina or genitalia by the penis. Ejaculation is not required. A woman is unconscious of the nature of the act if she is unconscious or asleep or not aware that the act is occurring. The defendant is charged in counts 9 and 10 with engaging in lewd conduct in public in violation of Penal Code Section 647A. To prove that the defendant is guilty of this crime, the people must prove 5 elements. Number 1, the defendant willfully engaged in the touching of his own genitals. 2, the defendant did so with the intent to sexually arouse or gratify himself or another person, or to annoy or offend another person. 3, at the time the defendant engaged in the conduct, he was in a public place or a place open to the public or to public view. 4, at the time the defendant engaged in the conduct, someone else who might have been offended was present. And 5, the defendant knew or reasonably should have known that another person might have been offended by his conduct or was present. Someone commits an act willfully when he or she does it willingly or on purpose. Now, as used here, a public place is a place that is open and accessible to anyone who wishes to go there. The defendant is charged in count 11 with elder abuse in violation of Penal Code Section 368, subdivision C. To prove the defendant is guilty of this crime, the people must prove 3 elements. Number 1, the defendant willfully inflicted unjustifiable physical pain or mental suffering on Jane Doe number 5. Number 2, Jane Doe number 5 was an elder. And 3, when the defendant acted, he knew or reasonably should have known that Jane Doe number 5 was an elder. Someone commits an act willfully when he or she does it willingly or on purpose. An elder is someone who is at least 65 years old. Unjustifiable physical pain or mental suffering is pain or suffering that is not reasonably necessary or is excessive under the circumstances. Now, the defendant is charged in count 12 with battery against an elder in violation of Penal Code Section 243.25. To prove the defendant is guilty of this crime, the people must prove 3 elements. Number 1, the defendant willfully touched Jane Doe number 5 in a harmful or offensive manner. 2, Jane Doe number 5 was an elder. And 3, when the defendant acted, he knew or reasonably should have known that Jane Doe number 5 was an elder. Someone commits an act willfully when he does it willingly or on purpose. It is not required that he or she intend to break the law, hurt someone else, or gain any advantage. The slightest touching can be enough to commit a battery if it is done in a rude or angry way. Making contact with another person, including through his or her clothing, is enough. The touching does not have to cause pain or injury of any kind. Conviction of a sexual assault crime may be based on the testimony of a complaining witness alone. Now, the people have presented evidence that the defendant committed the crimes of kidnap with intent to commit rape or oral copulation as charged in count one, rape by force or fear is charged in counts 2, 4, and 7, oral copulation by force or fear is charged in count 3, sodomy by force or fear is charged in count 5, indecent exposure is charged in count 6, and rape of an unconscious person is charged in count 8. If the people have proved beyond a reasonable doubt that the defendant committed one or more of these specific crimes I just enumerated, you may, but are not required to, conclude from that evidence that the defendant was disposed or inclined to commit sexual offenses, and based on that decision also conclude that the defendant was likely to commit and did commit the other sex offenses charged in this case. If you find the defendant committed one or more of these crimes, that conclusion is only one factor to consider along with all the other evidence. It is not sufficient by itself to prove the defendant is guilty of another crime. The people must still prove each charge and allegation beyond a reasonable doubt. Now, with respect to counts 7 and 8, this following instruction only applies to these two charges. These are the charges from 2003 involving Jane Doe number 4. There's a special allegation that is attached to count 7 and count 8. In order to find the special allegation true for 7 and 8, the people must prove two things. Number 1, the crime involves substantial sexual conduct, and 2, there is independent evidence that clearly and convincingly corroborates Jane Doe number 4's allegation. Substantial sexual conduct means penetration of the vagina or rectum of the victim by the penis of another or by any foreign object, or a copulation or masturbation of either the victim or the offender. Now, in this jury instruction, there is a different burden of proof. It's by clear and convincing evidence, which is not as high as beyond a reasonable doubt. You still must find the defendant guilty, that you can only find the defendant guilty of all charges if you find that people have proved the case beyond a reasonable doubt. This clear and convincing element only applies to this special allegation for counts 7 and 8. Clear and convincing evidence is defined as follows. Clear and convincing evidence of the corroboration means evidence of such convincing force that demonstrates, in contrast to the opposing evidence, a high probability of truth of the facts for which it is offered as proof. Such evidence requires a higher standard of proof than proof by a preponderance of the evidence. Proof by a preponderance of the evidence means it is more likely than not that the fact is true. So clear and convincing evidence is a higher burden than clear and convincing evidence, but less than beyond a reasonable doubt. Independent evidence may include evidence of the defendant's sexual misconduct against a separate victim. Such sexual conduct, if believed by you, may standing alone constitute independent evidence that clearly and convincingly corroborates Jane Doe number 4's allegation. Independent evidence is evidence that is separate and apart from the testimony of Jane Doe number 4. Now, as I mentioned with respect to that count, there are allegations that apply to some of the charges. And when you get the verdict forms, you will see, for example, I'll just give you an example. This is the verdict form for count 2. It talks about rape by force or fear is charged in count 2. And there's an area to find the defendant guilty or not guilty of this charge. If you find the defendant not guilty, you're done with this charge. You don't need to worry about it anymore. Only if you find the defendant guilty beyond a reasonable doubt do you then go down and address the allegations that are charged for each charge. So there's the independent charge for each count, and then some of them have allegations that you must determine whether are true or not if you find the defendant guilty of the underlying charge. So if you find the defendant guilty of the crimes charged in counts 2 or 3, you must then decide whether for each crime the people have proved the additional allegation that the defendant kidnapped Jane Doe number 1, increasing the risk of harm to her. You must decide whether the people have proved this allegation for each crime and return a separate finding for each crime. To prove this allegation, The people have to prove 5 elements for the allegation itself. Number 1, the defendant took, held, or detained Jane Doe number 1 by the use of force or by instilling reasonable fear. 2, using that force or fear, the defendant moved Jane Doe number 1 or made her move a substantial distance. 3, the movement of Jane Doe number 1 substantially increased the risk of harm to her beyond that necessarily present in the rape or oral copulation charges. 4, Jane Doe number 1 did not consent to the movement. And 5, the defendant did not actually and reasonably believe that Jane Doe number 1 consented to that movement. Substantial distance means more than a slight or trivial distance. The movement must be more than merely incidental to the commission of rape or oral copulation. In deciding whether the distance was substantial and whether the movement substantially increased the risk of harm, you must consider all the circumstances relating to that movement. The people have the burden of proving each allegation beyond a reasonable doubt. If the people have not met this burden, you must find that the allegation has not been proven. If you find the defendant guilty of the crimes charged in counts 2 or 3, you must then also decide whether for each crime the people approve the additional allegation that the defendant kidnapped Jane Doe number 1. You must decide whether the people approve this allegation for each crime and return a separate finding for each crime. To decide whether the defendant kidnapped Jane Doe number 1, please refer to the separate instructions that I have given you on kidnapping. You must apply these instructions when you decide whether the people have proved this additional allegation. The people have the burden of proving each allegation beyond a reasonable doubt. If the people have not met this burden, you must find the allegation has not been proved. There's also an allegation regarding multiple victims for counts 2, 3, 4, 5, and 7. So if you find the defendant guilty of 2 or more sex offenses as charged in 2, 3, 4, 5, or count 7, you must then decide whether the people have proved the additional allegation that those crimes were committed against more than one victim in this case. The people have the burden of proving this allegation beyond a reasonable doubt. If the people have not met this burden, you must find that this allegation has not been proved. For each count charged in this case, it is a separate crime. You must consider each count separately and return a separate verdict for each one. All right. Count 1 charges kidnap for rape or oral copulation. As I mentioned earlier, there's also what's called a lesser included offense for that crime. Now, the charged offense, there's a verdict form for the charge offense. It says verdict count 1. There's also a separate verdict form for what we call an LIO or lesser included offense. So what that means, what I'm going to explain to you right now, is I can only accept a verdict of guilty on the lesser included offense if you first find him not guilty of the greater offense. If you find the defendant guilty of count 1, you leave the second form blank, you don't fill it out. If you find the defendant not guilty of the charged crime in count 1, and only if you find him not guilty are you then to determine whether or not he's guilty of the lesser included offense. Now, this is CalCrim 3517, and when you go to fill out these verdict forms, you might want to take a look at this. When I say CalCrim, CalCrim is just short for California Criminal Jury Instructions, and it says CalCrim on the form. That's what that means. So this is CalCrim 3517. Before you fill out the verdict forms for count 1 and lesser included offense, I'd ask you to take a close look at this because there's 5 possible outcomes for this particular count and lesser included offense. So, if you all find the defendant is not guilty of the greater charged crime, you may find him guilty of a lesser crime, which in this case is simple kidnap, if you are convinced beyond a reasonable doubt that the defendant is guilty of that lesser crime. A defendant may not be convicted of both a greater crime and a lesser crime for the same conduct. Now, I will explain to you which charges are affected by this instruction. Simple kidnapping in violation of Penal Code Section 207A is a lesser crime to kidnapping for rape and oral copulation in violation of Penal Code Section 209B as charged in count 1. It is up to you to decide the order in which you consider each crime and the relevant evidence, but I can accept a verdict of guilty of a lesser crime only if you have found the defendant not guilty of the corresponding greater crime. For the charge with a lesser crime, you will receive a form indicating your verdict on both the greater crime and lesser crime. The greater crime is listed on a separate verdict form. When you reach a verdict, have the foreperson complete the form, sign, and date it. Now, follow these directions before writing anything on the forms. As I said, there's 5 possible outcomes. The first one scenario is as follows. If you all agree that people prove the defendant guilty of the greater crime as charged, you write guilty on the blank part for this crime, and you sign and date that return, and then you don't write anything on a lesser included offense form. Just leave it blank. That's one possible outcome. The second possible outcome is as follows. If you all cannot agree whether the people have proved the defendant is guilty of the greater crime as charged, in other words, you can't come to an agreement, unanimous decision, then you inform me only that you cannot reach an agreement and do not write anything on any verdict forms. You just say we are unable to reach a verdict on count 1, and you leave both of these forms blank. The third possible scenario is as follows. If you all agree that people have not proved the defendant is guilty of the greater crime, and you also agree that people have proved that he is guilty of the lesser crime, you would have fill out the first form as a not guilty for the greater crime, and then you fill out the not guilty area on the lesser included offense, and you must not write anything on this lesser included offense form unless you have first written not guilty on this form. So that's the third possible scenario. You following me on this? All right. Then now the fourth possible outcome is as follows. That's why I told you need to read this before you fill out the jury form. The fourth possible scenario is if you all agree that the people have not proved the defendant is guilty of either the greater or the lesser crime, you just write not guilty in the blank part for both the greater crime and lesser crime. All right? And then you're done. Now, the fifth possible scenario is as follows. If you all agree that people have not proved the defendant is guilty of the greater crime, but then you all cannot agree on a verdict for the lesser crime, you would write not guilty on the form for the greater crime. And you can probably figure out by now with this form, you leave it blank, and you report to the court that you cannot reach a verdict on the lesser included form. Now, whenever I tell you that people must prove something, I mean they must prove it beyond a reasonable doubt. Now, when you go back to the jury room tomorrow, you will receive all these verdict forms, and they all read pretty much the same, except the language is different for each form. For example, for count 1, it says, we, the jury in the above entitled cause, find the defendant, Kellen Winslow II, and there's a blank. Underneath the blank, it says guilty/not guilty of the crime of kidnap for rape or oral copulation in violation of Penal Code Section 209 is charged in count 1. And it has regarding Jane Doe number 1. Now, when you return your verdict, you actually have to write the word or words on this line. You just can't circle guilty or circle not guilty. You have to write the word or words on that line. The foreperson then signs it and dates it, and that's how you complete the verdict form for each count. All right, so that concludes the preliminary jury instructions. We're going to take a break for the day, and we'll see you back here tomorrow morning at 9 o'clock. When you come back tomorrow morning at 9, we're going to go right into closing arguments. As I said before, I don't think it's fair, for example, to have the people present their argument today, the defense present their argument today, and then come back tomorrow and just hear from the people on the very last day before you go out for jury deliberations. And based on the timing, there's no way we can fit them in tonight. Also, it gives both the defense and the prosecution an opportunity to fine-tune our closing argument and make it a little more clear for you to understand during the course of the closing arguments. So again, we'll see you back here tomorrow morning. I want you to be extra vigilant tonight. Make sure you don't watch any news coverage or read any news accounts of this case from any source whatsoever. And have a good night. We'll see you back here tomorrow morning at 9 o'clock. Please be on time. We'll see you tomorrow morning at 9. All right, the record will reflect that the jurors have left the courtroom. I noted in 1203 when I read it, it included the term robbery. I read it once but didn't repeat it. Any objection to the court just deleting robbery from that? Doesn't apply here.
No objection.
Okay, I'll just white it out. And are there any other requests at this time?
Yeah, Your Honor, I guess we will submit verdict forms tomorrow that are cleaned up a little bit, and that has separate the issues out, and, I mean, because what I'm looking at is it's just like one big paragraph.
Okay, you can submit
Yeah.
whatever you want. We'll
Okay.
take a look at it. In fact, why don't you email it to us today, and we can take a look at it? Are they different? What's the objection to the verdict forms that have been submitted? They're
Well,
not separated, or what?
yeah, the ones that I'm looking at are just like a paragraph, so it's separated out. If you answer not guilty, you don't even need to answer the additional questions, that sort of thing. Just clean it up a little bit.
All right, well, maybe you could meet with Mr. Owens and come to an agreement. If not,
Okay.
if there's some dispute as to the form, then we can deal with that tomorrow. So why don't we
Okay.
get here, well, we can just do it tomorrow before we send the jury out. So
Yeah.
just get here at 9. I know you guys have a lot of work to do tonight and tomorrow morning, so
Okay.
we can address the issue of the verdict forms after the jury goes out. It will be quick, I think.
Yeah,
Are there any further requests?
not by the defense.
No.
All right, we're in recess. See you tomorrow morning at 9. Thank you.